The UK has rewritten its immigration playbook in 2025, and the changes affect everyone, from skilled professionals to international students and families hoping to reunite. Did you know the salary bar has been raised to over £41,000, or that some care jobs are no longer eligible for visas? Even settlement, once a 5-year milestone, may now take a decade. These aren't minor tweaks, they're life-changing rules that could decide your future. Whether you're applying soon or already in the UK, here are the 10 immigration laws you absolutely need to know this year. Number 1. Raise in skill level for skilled worker visas. The United Kingdom has reshaped its immigration landscape in 2025 by introducing a higher threshold for those applying under the skilled worker route. From July 22, 2025, most roles now require qualifications at RQF level 6 or above, which translates to degree-level skills. This marks a decisive shift away from medium-skill occupations that were previously accessible under the skilled worker visa. For many international applicants, especially those in trades and service roles, this change creates a significant barrier to entry. The message is clear: the UK wants to prioritize applicants with advanced qualifications, technical expertise, and professional credentials. For individuals planning to apply, this new rule means evaluating whether their occupation and educational background still qualify. Some industries like health, education, and certain technology sectors may retain exceptions for specific roles, but the majority of applicants will need to demonstrate degree-level capability. This doesn't just mean holding a diploma. The Home Office assesses the skill level of the occupation itself, not just the personal qualifications of the worker. For example, a care assistant role is no longer eligible even if the applicant personally holds a university degree, because the job itself is classified below the required skill threshold. This shift will push many hopeful migrants to either upskill or seek alternative visa routes. Those considering the UK as a work destination must now look closely at professional pathways, postgraduate study options, or employer sponsorship in higher skilled roles. Employers, on the other hand, face a reduced pool of eligible overseas candidates and may need to adapt recruitment strategies or offer training to meet these rising standards. For applicants, the key is to act early, check the official job codes carefully, and explore whether upskilling could open the door to UK opportunities under the tougher 2025 framework. Number 2. Higher salary thresholds for skilled worker visas. Another defining shift in 2025 is the significant increase in salary requirements for skilled worker visa applicants. The general salary threshold has risen sharply, with most roles now requiring earnings of around £41,700 per year. This move is designed to attract highly qualified professionals while discouraging applications for lower-paid roles. For many individuals, particularly those entering industries where salaries are traditionally below this level, this change represents one of the most challenging barriers to overcome. The UK government's goal is to ensure that migration contributes to the economy by prioritizing applicants in higher-paid, high-demand sectors. For prospective workers, this rule demands a realistic assessment of whether their potential job offer meets the new threshold. It is no longer sufficient to simply secure a sponsor. Applicants must ensure their contract reflects the required wage. Some exceptions exist, such as for certain health and education jobs, but even these categories now face stricter salary floors than in the past. It is also important to remember that the Home Office evaluates pay on both annual and hourly bases, meaning applicants cannot rely on inflated working hours to bypass requirements. Employers who wish to sponsor international staff must align with these new figures, which could reshape hiring strategies across industries. Applicants should approach this change with strategic planning. Those in lower-paying sectors may need to seek opportunities in industries with higher earning potential or explore additional qualifications that lead to better-paying positions. Negotiating salaries with prospective employers becomes more critical than ever, and understanding how your specific occupation's going rate is calculated is essential. For those already in the UK, it may mean switching employers, upskilling, or carefully timing applications to meet the updated salary standards. This law reinforces the importance of preparation, clarity, and financial readiness in today's UK immigration system. Number 3. Restrictions on health and care worker visas. The UK has long relied on international recruitment to support its health and care sectors, but from July 2025, the government has imposed strict new limits. The Health and Care Worker Visa, once one of the most accessible pathways for overseas applicants, now faces restrictions specifically targeting adult social care roles. New applicants can no longer directly enter these positions from overseas. For those already in the UK, switching into the health and care route requires at least 3 months of employment in a qualifying role, making the process far less flexible than before. This marks a major policy reversal aimed at reducing migration through care sector recruitment. The impact of this change is substantial, particularly for individuals who had planned to use care roles as an entry point into the UK job market. Previously, these jobs offered a relatively straightforward sponsorship pathway, even for applicants without degree-level qualifications. Now, candidates must explore alternative routes such as higher-skilled healthcare positions, postgraduate study visas, or skilled worker visas in other industries. Employers in the care sector are also affected, as their ability to fill urgent staffing shortages with international talent is now severely constrained. This creates additional pressure on an industry already struggling with high vacancy rates. For those determined to pursue opportunities in UK healthcare, strategy is key. Applicants should carefully review the updated list of eligible roles within the health and education sectors, focusing on positions that still qualify under the skilled worker route. Upskilling into roles such as nursing or senior healthcare positions may provide a more secure path. Meanwhile, individuals who had planned to bring dependents under the Health and Care Worker Visa will need to reassess family plans. These restrictions highlight a critical shift in UK immigration routes that were once widely accessible now demand far more foresight, planning, and adaptability. Number 4. Longer time to qualify for settlement, indefinite leave to remain. A major update shaking the immigration system in 2025 is the proposed extension of the residency requirement for indefinite leave to remain. Traditionally, most visa holders could apply for ILR after 5 continuous years of lawful residence. The new reform, however, extends this period to 10 years for a wide range of visa categories. This effectively doubles the time applicants must spend in the UK before securing permanent settlement rights. The government argues that this change ensures a stronger commitment to integration and contribution before applicants gain long-term residency. For migrants, this new timeline creates several practical hurdles. Doubling the wait period means longer dependence on visa renewals, higher application fees over time, and more stringent monitoring of compliance with immigration rules. Families planning to settle together must also reassess their strategies, as dependent visas will need to be extended repeatedly. While some specific visa categories may retain shorter routes to settlement, the majority of workers, students, and their families will be directly affected by the new 10-year benchmark. This policy reflects the UK's wider push to reduce net migration, while reserving settlement rights for those with sustained economic and social ties. Applicants must now adopt a long-term mindset when planning their UK journey. Careful record-keeping becomes essential, as any gaps or breaches during the 10-year period could jeopardize eligibility for ILR. Financial planning also takes on greater importance, given the repeated renewal fees and rising immigration costs. For many, the ILR milestone may feel further out of reach, but preparation and consistency will be the keys to success. This extended timeline underscores the government's intent. Settlement in the UK is no longer a short-term achievement, but a long-term investment requiring patience, stability, and resilience. Number 5. Increased fees and sponsorship costs. The financial landscape of UK immigration has shifted dramatically in 2025, with a steep rise in application and sponsorship costs. The Certificate of Sponsorship Costs, a mandatory document for skilled worker visas, saw its fee jump from £20.39 to £50.25. This sharp increase affects not only applicants, but also employers, who must absorb these costs when sponsoring international staff. Alongside this, most visa and immigration application fees have risen by around 7%, making the entire process more expensive than ever before. The aim behind these adjustments is to ensure that migrants and sponsoring companies carry more of the financial burden associated with the immigration system. For individuals, these rising expenses mean careful budgeting is now critical. A skilled worker visa applicant must account not only for the application fee, but also the immigration health surcharge, biometric fees, and now significantly higher sponsorship charges. Families applying together face even greater costs, as each dependent incurs separate fees. Employers, particularly in sectors like healthcare and education where international recruitment remains essential, are also feeling the pressure. Smaller companies may find it increasingly difficult to manage these higher sponsorship expenses, which could reduce opportunities for overseas applicants. Applicants must prepare for these financial realities before beginning their visa journey. Researching the total cost up front, including hidden charges, helps avoid unpleasant surprises later. Workers may also need to negotiate with potential employers to clarify whether the company will cover the sponsorship costs or if the burden falls on the applicant. Planning well in advance, saving strategically, and exploring whether any fee waivers apply can make a real difference. This law reflects a growing trend. Immigration to the UK is not only about meeting skill and salary thresholds, but also about proving financial readiness to manage the higher costs of securing legal status. Number 6. Reduction in eligible jobs for skilled worker sponsorship. From July 2025, the UK has narrowed the scope of roles available under the skilled worker visa, cutting down opportunities in sectors once considered accessible for international applicants. Jobs that were previously classified at medium skill levels have been removed from the eligibility list, while some roles will remain only temporarily until they are phased out completely by 2026. This restructuring signals a government strategy to push the labour market toward higher skill levels, aligning with the broader immigration reforms that emphasise degree-level qualifications and higher salaries. For many applicants, this change dramatically alters career planning. Occupations such as care assistants, certain hospitality roles, and other medium-skill jobs no longer provide a pathway to sponsorship. Even applicants who may have secured offers in these areas before the change must now verify whether their specific job code remains valid. Employers too face disruption, as industries that relied heavily on international recruitment for lower or medium-skilled positions must reassess workforce strategies. This reduction creates a sharper divide between high-demand professional sectors, such as healthcare and technology, and those deemed less essential to the UK economy. Applicants navigating this new environment must approach their options strategically. Checking the updated Home Office occupation lists is now a crucial first step before pursuing sponsorship. For those whose roles have been removed, the focus shifts to either retraining for eligible positions or exploring alternative immigration routes, such as study visas or graduate visas that might later transition into skilled roles. Employers who still wish to attract overseas talent need to adjust quickly, potentially offering training programs that raise staff into qualifying roles. This law underscores a clear shift. The UK is no longer open to broad categories of workers, but is tightly directing its immigration system toward roles that deliver higher long-term value. Number 7. Stricter grounds for refusal. In 2025, the UK tightened the grounds on which visa applications can be refused, making the process more rigorous than in previous years. The Home Office now applies enhanced scrutiny, not just to the standard requirements like financial stability and job eligibility, but also to broader considerations such as personal history, character, and compliance with previous visa conditions. This expansion means that even small oversights or past issues could become significant barriers. The update reflects the government's drive to ensure that only applicants who meet both professional and personal integrity standards are granted entry or settlement rights. For applicants, this shift introduces higher stakes. Any prior immigration breaches, undisclosed criminal convictions, or false information in an application can now lead to immediate refusal. Even administrative errors, such as failing to provide correct documentation or missing deadlines, carry heavier consequences. Those applying for visas must also be aware of stricter checks on health conditions and public safety concerns. This heightened enforcement aims to prevent misuse of the system, but it also creates a more challenging environment for genuine applicants who must ensure their submissions are flawless. Success under these rules demands thorough preparation and transparency. Gathering accurate documentation, keeping records consistent, and disclosing all relevant information are now essential steps in avoiding refusal. Applicants may also benefit from professional advice to ensure nothing critical is overlooked. Employers sponsoring overseas staff must also stay vigilant, as errors in sponsorship paperwork could lead to rejection and potential penalties. By raising the bar, this law highlights the UK's intention to safeguard its immigration system against fraud and error. For genuine migrants, the lesson is clear: precision, honesty, and attention to detail are no longer optional. They are central to achieving approval. Number 8. Restrictions on dependents and family reunion. One of the most impactful changes in 2025 is the tightening of rules around dependents and family reunion. Previously, many visa categories allowed workers and students to bring partners and children relatively easily, provided they met basic financial criteria. Under the new framework, dependents are restricted in several visa categories, particularly those tied to lower salaried roles or occupations no longer on the eligible list. This change reflects the government's effort to reduce overall migration numbers, while ensuring that only applicants in high-demand, well-compensated roles can reunite with their families in the UK. For families, these restrictions create difficult choices. Many workers may find that although they qualify for a visa themselves, they cannot bring their spouse or children under the same route. For example, certain skilled worker visas with salaries below the new threshold now exclude dependent rights, leaving applicants to either increase their earnings or explore alternative immigration categories. Even where dependents are allowed, higher financial requirements and stricter documentation checks apply, making the process both more expensive and more complex. These obstacles can disrupt family plans, delay reunification, and add emotional pressure to those building a new life abroad. Applicants must approach this law with clear planning. Before accepting a job offer or committing to a visa pathway, it is crucial to confirm whether dependent visas are permitted. Families may need to explore different strategies, such as one partner applying under a qualifying route, while the other pursues study or graduate visas. Financial preparation is equally important, as proof of income and savings is now more closely scrutinized. For those committed to bringing loved ones to the UK, patience and flexibility will be essential. This rule sends a clear message: family migration is no longer guaranteed, but must be carefully earned under stricter requirements. Number 9. Updates to visitor, student and graduate routes. In 2025, several adjustments were introduced to the visitor, student and graduate visa routes, each designed to tighten control while still supporting the UK's education and tourism sectors. For visitor visas, the list of permitted activities has been refined, clarifying what short-term travellers can and cannot do during their stay. At the same time, student visa rules have become stricter, with sharper requirements for financial proof, documentation, and limitations on dependents. The graduate route, which allows students to remain in the UK after completing their studies, has also seen updates to eligibility and switching conditions, reflecting the government's aim to balance opportunity with oversight. For international students, these changes carry significant consequences. Financial requirements mean applicants must demonstrate not only the ability to pay tuition, but also to support themselves and any dependents without reliance on public funds. Certain students may no longer be able to bring family members unless they are studying at postgraduate level in specific fields. Meanwhile, graduates seeking to transition into work visas must ensure that their roles meet the new higher thresholds for skill and salary. This creates both opportunities and challenges. While the graduate route still offers valuable post-study work options, it is no longer as flexible as in previous years. Applicants must adapt quickly to succeed under these updated rules. Students should plan their finances carefully, ensuring they can meet maintenance requirements before applying. Those considering the graduate route should target industries that remain open under the skilled worker framework, particularly in healthcare, technology, and education. Visitors, too, must pay closer attention to permitted activities to avoid accidental breaches. These updates reflect the UK's broader immigration strategy to remain open for education and talent, but under a framework of tighter rules, greater financial scrutiny, and clearer limits on long-term opportunities. Number 10. Visa suspensions linked to deportation agreements. A new and highly consequential development in 2025 is the UK's decision to link visa availability to deportation cooperation agreements with other countries. Under this rule, if a nation refuses to accept the return of its nationals who have no legal right to remain in the UK, the government may suspend or restrict visas for citizens of that country. This policy was introduced to strengthen enforcement of immigration control and ensure that removal processes are not undermined by diplomatic deadlocks. It also signals a tougher stance on countries that fail to cooperate with the UK on returns. For applicants, the impact of this law could be profound. Even those who meet all visa requirements, such as skill level, salary thresholds, and sponsorship, may face restrictions simply because of their nationality. Students, workers, and visitors from countries that fall into dispute with the UK government could suddenly find themselves unable to secure a visa. Families planning reunification may also be caught in the middle of these political decisions, with applications delayed or rejected despite meeting individual eligibility standards. This introduces an additional layer of uncertainty where immigration outcomes depend not only on personal compliance but also on international relations. Navigating this environment requires vigilance. Applicants should stay informed about their country's diplomatic standing with the UK and watch for government announcements on suspended or restricted visas. Those already in the UK must also remain cautious, as visa renewals could be affected if their country becomes subject to restrictions. Seeking alternative immigration pathways, such as study or work opportunities in sectors with high demand, may provide some resilience. Ultimately, this law emphasizes that immigration is not only about personal qualifications, but also about global cooperation, where politics and policy directly shape individual futures. The immigration landscape of the United Kingdom in 2025 has shifted into one of the most challenging frameworks we've seen in years. With higher salary thresholds, tougher skill requirements, restrictions on dependents, and even the possibility of visa suspensions tied to international agreements, the rules may demand far more preparation and awareness. For many applicants, what once felt like a clear path to the UK has become a journey requiring careful planning, financial readiness, and long-term commitment. These laws are not simply administrative updates. They redefine who qualifies to live, work, and settle in the country. For students, the focus must be on financial stability and clarity about post-study options. Workers must pay closer attention to eligible job codes, salary benchmarks, and employer sponsorship obligations. Families face added layers of earning to reunite under the new restrictions, while those aiming for permanent settlement must accept a longer 10-year timeline. Every step now carries higher stakes, making mistakes or oversights costlier than ever. Yet, while the system has become more demanding, opportunity still exists for those who prepare strategically. High-demand sectors like healthcare, technology, and education continue to offer viable routes, and careful financial and professional planning can still unlock the door to a future in the UK. The key is staying informed, proactive, and adaptable as the system evolves. Immigration is no longer just about qualifications, it's about endurance, strategy, and resilience. By understanding these 10 laws, you place yourself one step ahead in navigating the UK's new immigration reality.